hopefully, this should be streaming now, and we can kick this off. I have something of a yarn. So what I'm going to do, I'll just type a little welcome message. Hello, and enter. How long is that going to take to pop up? 4 seconds, 5 seconds, 6 seconds, 7 seconds. Oh no. Oh, there we go. And you can't even read it anyway. It's not particularly effective, is it? Having a pop-up thing there if no one can see it on those screens. I mean, is that even legible at all? I don't think it is. It's right. Rather than you can't see that one there. Okay. So I'm trying to think of ways around doing that. Whether is it just something that maybe it's just bigger font. I think just a bigger font would help, or is it just fundamentally because it's so slow as well? I'm interested to hear what you guys' feedback is in relation to this. So we'll do this, and hopefully if the other set of Emma pops in as well, we can ask questions and answer them. So. The other thing I'm finding too with these shirts, where they've given us a bunch of these shirts, and the trouble is it has JCU Law written on the back, so wherever I go, everyone knows exactly. So I can't do anything naughty. I just call the law school for the tall bald guy. Yeah. Except the other day when there was a miscommunication between me and my ex-wife, so I literally walked into a primary school wearing this shirt and then walked out without a child. Doesn't look suspicious at all. All right. So what I'll do, even though I said 6:30, I'll talk about the assignment first. Like I said, I've still got 4 that I've still got to mark, and so I'm aiming to get that done before midnight. So we'll see how we go. As I said, it's a week from when it was submitted. So there we go. They weren't great by and large of the ones that I've done, which again is only 15 or 16 from the class. And there's a couple of things. I'm going to take on the chin because either I didn't explain them very well, or it wasn't clear from the question. And a couple of them I think are style things, which I'll talk to you guys about because some things will be relevant, particularly for your exam. But really the key sort of theme that came throughout is actually to do with citations. And for most disciplines, citations are not, they're important. You've got to cite your sources. You've got to demonstrate that when you're using somebody else's ideas, that you're acknowledging them. That's really the purpose of citations for most disciplines. And it's something that I've realized when going through and looking at you guys' work, that I don't think I made overtly enough. That's not actually how things work in law. In law, the purpose of citation is actually to add weight and authority to your argument itself, because the quality of sources is actually like a little hierarchical thing in terms of which is literally more authoritative if a matter goes to court. Remember in the first few weeks we talked about the doctrine of precedent, and a contemporary decision completely on point in the Australian High Court is going to be far, 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 far more important than a Canadian decision 50 years ago in a lower court, or something where the facts are slightly different, for example. And really that there is an underlying quality of your sources. It does matter. And for this subject, because it's introductory, essentially in terms of your the legal rules and principles you're using, that you can use the basics when talking about the elements of a contract. That comes from Carbolic Smokeball, Carlisle. It's perfectly fine to do that, and you'd be crazy in your exam to not do that. if you need to talk about legal rules and principles in your exam. And I can assure you, you do. So that's really the first sort of takeaway that I've had from the assignments that I've done. It's that being able to demonstrate when you say something, when you say a particular law, the battle of the forms, usually the person accepting the offer, for example, on their form wins, for example, as a rule. And that's fine and all to explain that. You really have to say where it comes from. And it gets, of all of the things in the assignment that was the most problematic, the negligence case, the negligence problem was by far the most problematic in terms of doing that. Negligence is the hardest thing to know, and it's also quite commercially relevant. So it is something that you ought to know when you walk away from the subject. And the strategy that I give the undergrad law students, and I'll give to you guys as well when going into your exam, is really to be able to separate out the rules and the explanation of the rules from anything to do with the facts. Literally, they should be agnostic to each other when you're writing these things out, because the rules aren't going to change. When you're explaining to somebody what is negligence, you will reply by saying essentially a pre-rehearsed answer. Or negligence is a tort, a mechanism for recovering compensation for civil wrongs, where a person who owes you a duty of care, and that where they've fallen below the standard that duty requires, and fallen below that standard has caused you harm that was not too remote and is recognized in our legal system, then you can seek compensation to try and put you, as far as money possibly can, back to where you were. And again, if I was doing this in an exam context, you'd be quoting for each of those little rules that I've just mentioned a source. Donahue and Stevenson and Sullivan and Moody, all of the sections and subsections from the Civil Liabilities Act, in order to add credence or add weight to that. Because at the end of the day, you and I can say whatever we like. We can walk around the street telling people that this is wrong and this is wrong and this is right. I'm right about this in terms of legal stuff. Our opinion doesn't matter. It's really the weight of authority that we have behind us, both from Parliament and from the common law. That's really that first sort of takeaway that we have from that. And structuring these answers in your exam, you go a long way if you've already pre-rehearsed a whole bunch of these things. Okay, what else was there? Generally, the first question was really well done. First question, the one on jurisdiction. I think you guys had gone through. It was really a lot more research oriented, so you guys could go through, find the Queensland website, find this. One other thing, and this is something I hope that you guys take away to your other subjects, is that a lot of people neglected their audience. In all four of those tasks, you were advising the general manager of a medium-sized business. And the style, particularly the opening and the closing bits, what does a general manager want to be reading? Hi. Because just going straight into, the tort of negligence is this, that, and the other thing. You appreciate, if you were giving this to another human being who doesn't know anything about law, what are the first few sentences they're going to be expecting to read? And this is just as a strategic thing. This mode of thinking is really useful for your other subjects as well. And also your professional lives too. For you guys who are going to be in the accounting profession, you are going to be tasked with giving advice to people. And you're going to have to know and judge where your audience is in terms of how you go about starting it, how you lead into the advice that you're going to give by setting some sort of context. And that takes a bit of practice, sort of backwards and forwards. Try and identify who your audience is, particularly in circumstances where you know the people well. That has its own challenges, but in the problems from, for the assignments of this subject, appreciate that you've got a relatively bright, business knowledgeable person who knows nothing about law. And so explaining the legal principles from first principles, which we do learning the subject is fun. It's fun, absolutely. A tort is a civil wrong where you can seek compensation from those that have done you some form of harm. It's fun. That's the starting point. Okay, so is that identify the audience and citations, and I think some of you guys wrote way too little to be able to explain stuff. And I know I put a target set of words in there. The small little thing, and again, this is more for from the legal, weaselly legally types. If ever you read something that says there's no strict word limit, usually you can read into that. You can go over a little bit more. It's fine to write too much. It's basically a risk-reward thing. It's fine to write too much, provided it's not pages and pages. But you're still going to be in trouble if you write too little. And that's why I would be very, very surprised next week at this time that anybody would be walking out the exam early. You should almost never do that in any exam, and particularly law exams, because let you in a little secret, JCU, we're not allowed to mark destructively. If you say something which is sort of half right, and then you say something else which is a little bit more right later on, we can't take marks off for that. So if you've explained it not quite perfectly here, but then explained it a little bit better, the same thing a little bit better down here, you're going to get marks for that. We're not allowed to mark this. We don't start with 100% and we take marks off for getting things wrong. It's just not how it works. It's against that policy. Hey, okay. Do you guys have any other questions about assignment at all like that? I said I'll get that hopefully out tonight. If not, it'll be by tomorrow. It was a triple chance thing. I think there were 4. I think everybody answered 4. And if anybody didn't or whatever, I think everyone answered 4. So you got the highest 3 out of those. I'll probably post up all of the marks for all 4 if you want to, just for the sake of comparison. And then I'll just do a max on those. Okay. We'll probably kick off, actually. Probably kick off. Have some more pizza. Coming out 6:30. Let's kick off. Oh, am I the only person with pizza? Okay. If anyone else wants pizza, I feel guilty now. Sorry, I didn't get enough. Right. So, first things first, the exam. Where is it? It is in Building 18. I don't know if you guys got the announcement. It's the ground floor of the library, where the stairwell is on the far side. It's one of those sort of fancy new type rooms with the big round oval table things. So we should be fine in there. This class should have enough space for doing stuff. But just remember, because it's an open book exam, you're allowed to bring whatever you like, except library books for policy reasons. You can bring the book in. Now, as a rule of thumb, if you're having to open the book to read something, it's not good. Usually it's not good if you're having to open the textbook. Ideally, you want to have enough material that you've prepared in advance in order to be able to go and answer those things and grab things in first principle. I think the only times I've opened books in law exams is if I've looked at something and the facts are similar to a case and I can't remember what that case is. So I have flicked through. In fact, the 2 or 3 times I've done it unsuccessfully, and all 3 times I couldn't remember what that case was. With it was a nuisance case with the algae or something like that. And I'm like, oh, we learned this, but I couldn't connect it. And so that's one of the few times where you would go through and look at the book. But generally, with a lot of these things, if you know it, you'll know it, and you'll be able to write about it, and you'll have notes, and you'll have the lecture slides. You can print the lecture slides, take them with you. In fact, I put up on LearnJCU a docx file, so a Microsoft Word file, which is all of the lecture notes just combined into a single document. Print them out and take them. There's also a legislation. I haven't printed them out because they've done things to our printing. My printing's now all messed up, so I literally couldn't print, which is why I'm reading the exam from from the computer because I couldn't print them out. So there's I think it's 40-page thing, which has all of the legislation that you will need for this exam. To be honest, you actually don't need all of it. Don't give you little snippets here and there. You might just find it's helpful to have though, because some of the questions you actually can answer by flicking through, finding that piece of legislation and being able to answer it. So that's it. All right, so it's going to be at this time next week. It's a 2-hour exam with 20 minutes reading time. So what time does the bus go? Jean, who catches the bus after? Okay. All right, so is 20 past going to work? Quarter past? It's really up to you guys. And I'll need to know because I'm going to have to leave this on the recording because you've got to be there at 6. The time slot is booked from 6 till 9. And it's a case of, well, it's actually to do with latecomers. It's not, strictly speaking, it's not everyone who's in the room now. It's people that come late because they've got rules. I have to go back and check them about arriving too late for exams. There is a rule for that. All right, so how about we just try and kick off not far after 6. We'll go 10 past 6. It's kickoff time. All right, we'll make that sharp. I'll put that in an announcement as well. I said you've got 20 minutes reading time and then 2 hours to write. And again, with legal exams, when they say you can get your reading time, first thing you do, grab your pen, because while you can't write it in your exam script, you can scribble all over the exam script itself, the actual exam. What should I call it? The thing's got the questions on it. You can scribble all over that to your heart's content. Yeah, you can highlight, do whatever you like. In fact, there'll be scrap paper as well, so you can do that, right? The idea is that usually you can essentially just starting the exam. I think if you want to spend time reading it, it's fine. I'm going to tell you what each of the questions is going to look like right now, so the structure shouldn't be alien to you guys when you go through and doing that. And so that's it. But yeah, certainly you'll see this. Again, I've noticed this for subjects where I've had business and law students together. The business will pick it up and read it in the reading time, which sounds pretty logical, and the law students will pick it up and just start writing. All over the script, all over the scrap paper. They're always the ones that finish 3 books. You guys wouldn't have done the undergrad. Yeah. All right, so 20 minutes reading time, and then it's a 2-hour exam after that. Last year, they said the time was pretty reasonable. It's a formal exam. It's open book. Anything except library books. It's pretty straightforward. You can take a calculator if you like. I'm not sure you're going to need it. There is a very small amount of arithmetic. So if you really, really want to, you can bring a calculator with you, but you can't bring your mobile phone. I was one of those people very, very early on who won in a contest many, many, many years ago, just after the turn of the century. What we would now consider a smartphone. And I can remember this because my smartphone, I was allowed to take it to exams because the examiners had never seen one before. So for years, when I was doing accounting, I was allowed to do that. I didn't cheat or anything, but I could have. It was hooked up and you could use Excel on it and stuff. Anyway, so if you want to calculate, you guys, English second languages, your Latin English dictionary. I think I actually have to bring one with me, so I'll do that too if you really want it. It has to be Macquarie Dictionary, it's the preferred legal dictionary in Australia, and bilingual dictionaries. Fine. Again, it's an open book exam, so none of this is really that relevant to you guys. You can't bring your laptop. Yeah, I did get asked that question too here. No laptops, no phones. Also asked that phones go on silent and get put away in the bags at the front at the start. Pretty straightforward stuff. I've got here 1 times 18-page books. I actually don't know what books I'm going to have supplied to me. I'm just going to go and get books. You might get 2 10-page books. It really doesn't matter. I'm the only person marking them. And it's 50%. Consists of 5 questions. Each question is worth 10 marks, so it's just exactly, and marks apart questions are shown. All right. So, for your exam, again, this will be recorded, so you can either listen to this, or you can take notes, or you can do both. It really doesn't matter. Any comments on this thing here? In your exam, the first question is about contract and about tort. Basically, what I've done for this is to put a scenario. It's about 4 or 5 paragraphs. It's a scenario. It's got some numbers in it. And those numbers are going to relate to things like damages. All right, how are things going to sit? So just make note, when you open up this thing, you're going to see numbers. You're going to have to do the smallest bit of calculation. Basically, the calculation is simple. It's trying to determine which things are going to go into it. That's really that key part. And so, you guys, sorry? Oh, sorry. Okay. Okay. So, you have to know the elements of contract. It's like the first thing and the first substantive law bit that we do for the whole subject. Well, it's and not only just what the elements are they going to apply in a particular situation? So you're going to have to know what an offer is, acceptance of the offer, consideration flowing between the two parties. Those are the three physical elements. You'll have to know the rules for the intention to create legal relations, the rules for capacity, rules for legality and mutuality. To be honest, those last two, not really so important here, because we looked at legality and mutuality as part of the vitiating factors too, for things like mutual mistake, and the illegality as a vitiating factor. So it's really those key ones. You'll be given, in the scenario, something that may or may not be a contract. You're going to have to work out, is there a contract? And just saying yes or no for a 2-mark question is not going to get you 2 marks. You'll have to explain the contract needs the elements and whether or not it's going to apply. That actually goes to the next one as well. Right? So strictly speaking, it's 4 marks, but spread across 2 separate questions. So just make note. If you answer this one up here, it's okay. I'll work it out. I'm not the sort of person that, this one's got to be that one. That's fine. All right. Also, as part of that, you'll have to talk about negligence. The same problem has a contract component and a negligence problem. So it's a short, like I said, it's about 4 or 5 paragraphs. It's got some negligence bits and it's got some contract bits. And so you're going to need to explain negligence. The explanation that I had just before, you're going to have to be able to do that. And for reference sake, if there is a question that asks you to describe a particular rule, you should try and find a citation. If it's worth 1 mark, usually you can explain it well enough to not need a citation doing that, although it always helps, particularly if you're a little bit iffy in terms of how you've explained it, the citation will push you up to get that full mark. If the question's worth more than 1 mark and it asks you to describe legal rules or principles, then you must supply citations, a source of that legal principle you've had. And again, following Steve Gorrell's book with the notes and the lecture slides, which are largely drawn from that material, is very helpful in terms of doing that. Okay, now negligence obviously being a pretty important part of this subject, even though I only taught about it for sort of half a lecture. What you're going to need to do is really know and demonstrate to the marker that you know what each of those elements does. You need to functionally be able to explain how each of those elements operate. Duty of care element is that the duty of care is in situations where either the law imposes upon one party to another because there's an established category, or whether the particular circumstances and factors create one on the facts, the Donahue and Stevenson style, is something you need to be able to describe. You have to do that. And then once you've done that, you then have to explain with the breach element, which is assuming that a duty exists, what does that mean? What does this duty actually impose on people to do? And by and large, it's what's called an objective test. It's a reasonable person test. What would a reasonable person under this particular duty actually do? And that is an abstract test. It's a question of law. What would a reasonable person do? All right. And that's known as the standard of care. And the Civil Liabilities Act maps out certain things that the court must take into account when determining what that standard of care is. All right, so that's this first thing. Again, it's a two-step thing, because the second half of the breach stuff is that once you've determined what the abstract standard is, then you look to see what actually happened. And so that's really, I think that's a really, really important way of doing that. Map out an argument. And look, it sounds a little bit silly when we're writing these things out, because we're trying to essentially come up with a hypothetical situation. And you can imagine in the real world, in the court system, when you've got two parties, they'll be fighting tooth and nail to argue that a reasonable person ought to have put signs up on one side, usually the plaintiff, and the person ought not to have put signs up because they're too expensive, the defendant. That's really where it's at. They're both trying to argue what this abstract standard is a question of law, and try to convince the judge to phrase it in a certain way. These guys want it to be set at a high standard, these guys want it to be set at a low standard. It's an argument that the sides make. Once that is determined by the judge as a question of law, then we just look to see what actually happened. Did the defendant fall below that standard? Did they breach? Because the gap between the abstract standard of what a reasonable person would do and what this person actually did do, that is the breach, and that needs to be clearly explained. Explained. That, because the causation element that we'll get to in a second is all about the breach. It's about the gap between this and this. And it's huge. That particular part's really, really huge, because it's, by and large, the law students don't explain it very well either. They really, really don't. Okay. Now, for the third element, there's a couple of things we need to talk about here. The first one are the three tests that we talked about specifically in this subject. All right. What you'll find is that judges actually talk about these things in slightly different ways. Every different case, they'll explain them in different ways. So I have gone and sort of distilled this really into these three categories. You have the simple but-for test. Would the harm have not come to the plaintiff but for the breach falling below this standard? And so an example of this, the plaintiff would have to prove if there was a sign, she wouldn't have jumped in the water. All right, it's a simple but-for. You put the sign up, I wouldn't have jumped in. All right, and you can imagine sometimes that can be quite hard to prove. It can be a little bit tricky at times. And so the courts also use what we call the common sense test. What would, as an ordinary person looking at the situation, would they think that the natural meaning of the word cause actually applied here? Did falling below the standard, from what we as human beings think of that word cause, did that actually happen? I didn't describe that very well. It's basically almost a moment to take off our lawyer hats, which is hard for lawyers to do, by the way, for a period of time, because that's why we get a bit of a reputation for having no common sense, because this is a common sense test. We can't step out of it very well because we're so used to dealing with all of the legal rules and stuff. But what would an ordinary person looking at this particular situation have thought that falling below that standard caused harm to the person? That's really where that's at. That's the second one. The third category or type of test is the material and substantial cause. Look, in some situations, and again, this came from the asbestos cases, some situations you can't point to a specific thing that happened, but over a period of time, these guys fell below a standard of what a reasonably competent, in that case, manufacturer of asbestos products would have done. And when people got asbestosis, even though we couldn't point to a particular situation where, as a matter of an ordinary person's type test, we could say they caused your lung-related illness, and we can't argue in those situations that you would have got the lung cancer or whatever it was. You wouldn't have got lung cancer if you didn't work there, because there are people that get lung cancer that don't deal with asbestos. And there are some people that deal with a lot of asbestos and don't get lung cancer. And so this sort of logically is quite hard to do. And so what the courts developed is a test, and it's a marker in Booth is the case for this, where they said, look, we think that you've materially and substantially increased the risk through falling below that standard of care. Material and substantially increased the risk. And so that satisfies that test of causation. It's not an exact science. The courts try to use the test which is most applicable. And obviously when there's two sides arguing which is the most applicable test, they're going to never see eye to eye either. One side wants to win, the other side wants to lose. All right, so you do need to talk about that test and know and understand and be able to explain that back. Explain it back to me. Damages. You have to know about damages in contract and damages in tort. And you have to know about the fundamental difference between damages in contract and damages in tort. There's a fundamental difference. Nikhil, what's the fundamental difference? Oh, he's on his phone. Nimi, what's the difference? It's so funny because Steve Graw used to teach the subject, and Steve is the most no-nonsense guy. He'd literally go to the room and say, "You, what's the answer?" Gene knows the answer, though. Fundamental difference between contract and tort. In tort, damages are awarded to put you back, as far as money can, back to where you were. In contract, damages are designed to compensate the loss of the bargain, to put you where you would have been if the other side did what they said they were going to do. I'll tell you the story. It's kind of funny. So I have this business, which I'm literally only doing out of spite these days, selling these little collectible cards. I used to do this with a few of my friends, and we had a big falling out, but I'm still doing it. And some guy, one of the cards has gone missing in the post. So I said, I'll just refund the money. And he's like, oh, no, but I really want that card. And the contract lawyer in me is going, oh, he's right, because he got it at quite a discounted rate. And he just wants the actual card because it's worth more than the amount of money that he actually paid me. And he said, the lawyer in me is like, oh, no, this guy's completely right. Most people wouldn't know that rule. If you think about it, if you were going to buy something and you were going to on-sell it and they don't deliver that thing, how much money would you expect to get back if they didn't deliver the stuff? Well, the seller would always just say, oh, well, I'll just refund the money you paid. That's pretty logical, isn't it? But that's not how damages in contract law work. And again, that was one of the handful of takeaways that I wanted you guys to remember from this subject forever and a day. Damages in contract don't work like that. There is one exception to that. It's actually where the duties coexist. Duties, if there is the same duty in contract and in tort, those things can coexist. And that's actually to do with contributory negligence as well. So that usually there's no contributory negligence in contract law. Remember in tort, so for example, you guys give professional advice. Let's just say we all become accountants one day. You know? I've been eligible to do the professional exams in 2004, but yeah, I'm sure it'll happen one day. If you give advice and that advice is bad, all right, there's coexisting duties here. You've got a contract because you've presumably been paid, but there's also duty in tort. People owe a duty of care, giving advice to not fall below that particular standard. Now, most of the time, which do we want to be suing in, contract or in tort? No, contract, because if you take the advice and things go badly, right, in tort, they're supposed to put you back to where you were, not to where you would have been. So if they're giving you advice, particularly in terms of strategic projects going forward and doing stuff, there's more scope in contract law to advance yourself in your position. So you almost always want to be suing in contract. But there are some situations where that doesn't work. One of them, it's really, really important, is that the right to sue is different between the two causes of action. In contract, the right to sue arises when there's the breach. In tort, it's when the harm occurs. So what you could find, and this happened to me when I had a community legal case where we had a person who gave or received bad financial advice, but the 6-year rule applied because it was 6 years since the date of the advice, but the harm didn't come for a year or two after that. And so she could sue it, but only sue in tort. Couldn't sue in contract. And there is actually a statutory modification in the Law Reform Act. It says if the duties coexist, you actually can, as the defendant, argue contributory negligence. I haven't put this in the exam. Don't worry, this is new to you guys. Because I'm not sure I actually mentioned it in the lecture. If I am, I'm sorry. It's really for you guys if you're going off to be accountants and you are giving advice. It's good for you guys because it means that if you've got a contract and the other side are also negligent in taking your advice, you actually can rely on contributory negligence. You can't in other aspects of contract law. Right? So, for example, the sale of goods, no, there's no contributory negligence at all. So you sell goods, and you were somehow negligent in terms of how you sold them. Maybe I was 5 minutes late. All right, that's breach of contract. All right, but it's nothing to do with. There's no aspect of negligence that arises here. If I arrive selling goods, and the other person arrives, and they're a little bit late. All right, but that's not part of the performance of their contract, and the goods get destroyed or stolen. They were slightly negligent in terms of doing it. It doesn't matter. How do we determine who bears the loss? It's the person with title. It's all mapped out in the contract. Them being a little bit late to pick it up, if it's not a term of the contract, there's no contributory negligence at all. So that's something that people, again, in the real world, have a little bit of a hard time getting their heads around in terms of fault. Oh, but you were slightly at fault for doing this. It doesn't matter in contract. No one cares. Unless the duties coexist. Again, giving financial advice is one of those situations. Okay. Now, you need to know about the principles of damages in contract and in tort. You also need to do some calculations. Yeah, you've got to do some calculations. And you need to work out calculations in terms of whether something is in contract or whether it's in tort. This idea of putting people back to where they were as opposed to where they ought to have been. You'll need to know that, leave that in the back of your mind when you're answering the question. I won't talk too much about that. Okay. Question number 2 in your exam is, again, another scenario. This one's actually a little bit longer. 1, 2, 3, 4, 5, 6. It's about 6 paragraphs. 6, 7? Oh, you're all right. It's strictly speaking, it's 7. But one of them is just a single sentence for whatever reason. And it's about property, but it's kind of what other word? It's to do with things involving personal property. And so you have to know the rules from the property lecture or module, whatever we call it, in relation to personal property, finder's rights. You have to know a little bit about finder's rights. So go to that part and revise that part. In terms of who has the best claim. And these are worth 3 + 2 + 2. So you're going to need to have citations. So when you guys are going through and mapping out finder's rights, you need to go through and actually have sources for the legal principles that you're going to use. Armory's case, Parker and British Aviation, the water, the gas company, Ewells and the gas company, and the Sutherland Water. They're all in the lecture slides, but you'll need to know how and where to apply those. All right, and so just note there'll be a scenario. It'll involve people who may or may not have found things, but also you're going to have to talk about fiduciary duties and agency as part of that. Because if you find something and you're on the clock, who owns it? And that's because this happens. Yeah, that's right. And so you'll need to go, but you need to explain that. One of the things about law, particularly we find very early in the degree, there's a tendency, unfortunately, particularly mature age students, we have a tendency to learn something, internalize it, and then just know the answer. So somebody asks you something, you just tell them the answer. But like a lot of these things, we've got to actually unpack that a little bit, because your marks are going to be awarded for demonstrating you know where those rules come from. The weight of me saying something is very, very low. I'm not a High Court judge. The weight of me saying something backed by all of these things that High Court judges or clearly expressed will of Parliament have said is fine. That's how you do that. So just note, because they're worth 3, 2, and 2 marks for the finder's right stuff, you will have to, you'll have to really think about, you'll have to have, ideally to actually have sources with you as you go in. You'll need to know difference between possession and ownership, and different classes of, really how the interaction between those things work. The key salient differences between those things. It's a really important point in our world. People can possess things. I'm in possession of this chair, but in law, I'm in possession of this chair, but I'm also in possession of my mobile phone, which is upstairs in the office. It's not an ordinary definition. Possession is a modified statutory definition. It's a modified common law definition. It is wider than that. But in the context of business law, what we care about are the packets or the bundles of rights that ownership have, and contrasting that. Oh, somebody looks. Oh, right. Role playing. Good job. So the packets of rights involved with ownership and the packets of rights in possession. And you'll need to explain that this one's better than this one. Why? Why is that? And this actually require a little bit of thought. I think you'll find that this is a question where you want to go and talk about those bundles of rights and how they're different. I think that's a key thing just to note there, eh? Okay, and that's all question 2 anyway. Yeah. All right. The third question is also about property law. Oh, yeah, maybe I put too much property law in this. Anyway, but the first 3 marks are about real property. What's real property? Land and buildings, land and things that are attached to the land, so as to form part of the land and be enjoyed by future owners and occupiers of the land, also known as fixtures. So that's what real property is. That is different and distinct from personal property, which is also different, can be divided up into tangible and intangible things as well. Personal property. So we need to know the rules for co-ownership. And this is not just in terms of land, by the way, it actually applies to personal property as well. You can co-own things. You can co-own a car, you can co-own obviously a house, but you can co-own actually anything in our legal system. And you guys need to actually define and describe what that actually means. You need to be able to explain that back to me. What is it? And the different types of co-ownership. Remember we made this distinction between what we call tenants in common? That is where you have shares, essentially, and those shares can be alienated separately. So if I am in tenants in common, so tenants hyphen in hyphen common, I think it's hyphen, essentially one term. Tenants in common means that the shares can be alienated or disposed of, so sold usually, or given away, or moved into a trust, but not destroyed. Not destroyed. You actually can't destroy them as such. You can't destroy half your house. It doesn't work like that, because the idea is you are co-owning that particular house or that particular piece of property. If it could be divided in half, it's really 2 items of property that you would be talking about. Co-ownership applies across the whole thing. Tenants in common means that the share can be sold separately. Doesn't require the other person's permission. And that is contrasted with joint tenancy. Joint tenancy is still co-ownership, but you can't alienate your share. You have it until you die. And what happens when you die? Oh, no, that's a little bit metaphysical for this lecture, isn't it? Akil, what happens if you've got 3 joint owners of a piece of property, what happens when one of them dies? The other 2, they get it, that's right. So the right of survivorship means the last person gets the lot. And that, and again, I'm curious, I want to do some investigating on that actually, how that works in places where there are larger families, like in the subcontinent, how the things like that operate and work, because it was always problematic in Europe and in ye old England to have that idea of the family farm. And so you had 4 brothers would have the family farm, but then the last one, all of his kids get the benefit of the farm, and the others, in theory, get nothing. Now, equity can intervene, but we don't talk about that in this subject. And under the statute these days, you can convert a joint tenancy into a tenancy in common if also all parties agree. So that's it. You need to know that. You also need to know how mortgages work. How does a mortgage operate in terms of real property? What rights does a mortgagee, I always get these mixed up. Person who grants the mortgage. No, mortgagee. I always get the 2 mixed up. Sure, hang on. Mortgagor is the person who gets them. The person who receives the mortgage. I have the house. I get a mortgage. I'm the mortgagor. No, I'm the mortgagee. Yeah, so the bank is the mortgagor. Okay. All right, good. It's good thing we're clear on that, eh? Not putting that in there. But you do need to know how that charge does operate across the property and what rights does it give them. And we don't go too much into the actual rights to do this. I mean, they have the right to sell if you don't pay. But it's really whether or not that right to hold charge over the property, a mortgage, or over personal property, gives the particular party any other powers to do things. Do they become co-owners? So you'll have to have a little think about that. It's only worth 1 mark. All right, the other component for the property question is fixtures and chattels. I find it kind of find it funny, but the reason why we put these things in exams is not because it's particularly useful for your future business careers. Sure, you'll know from this point forward when you take over a lease, when you buy a house, check the fixtures and the chattels list. Go run around and check it, and you'll know that if things are left off it, then these rules are going to apply. But generally, just double check this. All right. The main reason we do this is that it's a really good example of law, actually doing law as a discipline. Here are some rules, principles. Here is a scenario. Apply those to these facts. And so it's just mechanically, it works out quite a good way to judge you guys in terms of how well you really aren't got to grips with this particular discipline. And so you have to start by describing the particular rule. Lemmy, what's a fixture? I just... All right. Fixtures. Oh, sorry, was that a shard? What? Fixtures are attached to it. Yeah, that's right. Yep, that's it. And chattels are personal property that picked up and moved around and best enjoyed and taken with you. That's really it. Do that. Yeah, that sounds good. Write something like that. You'll be fine. But then you've got to talk about the tests. So we talked about 3 tests. I found, by the way, as a law student, that this was kind of all over the show. Oh, this and that and the other thing. So again, I tried to really map that out for you guys. There are 3 tests. The objective intention test from Coronio's case. You've got the purpose of annexation. In other words, what's the fundamental nature of the object? And then you've got the degree, which is how stuck is it to the ground? How much is it going to mess the whole thing up if you pull it out? This one's more important than that one, more important than that one. And usually start with the contract, which is the ultimate indication of what the parties were doing at the time they're transferring the land. What's our intention? Okay, and so basically you'll be given a scenario. Oh, what's it got? Very short. Here's 4 items. Go to it. And you just apply those 3 rules. So just make note, it's actually a little bit of writing because there are 4 items and 3 tests. So you're going to have to do 12 things. Usually You explain the rules once and then apply it for each of the items. That's the logical way of doing it. Don't do it item and then do the 3 tests. I mean, you can do it however you like, but it's just less writing to explain the rules once. Okay. All right. Question 4 is entirely all 10 marks on copyright. So, yeah, I did talk about copyright. Yeah, we did. That's right. It's the only video that breached copyright. So I can't be shown in New Zealand. All right. So you do need to know this, and you're gonna have to know fundamentally what things can be protected by copyright. Now, each of these, there's 5 things you'll have to talk about, and you're going to have to cite. Yes, you're going to have to find a citation for each of them. Each of them, you could probably find a citation. So I'd be tempted to go through, and some of them are kind of broad, so you're probably going to get away with pretty much any case citation. But if there is an equivalent in the Copyright Act, make sure you've got that as well. And again, it's functional knowledge of how the Copyright Act 66 together is useful. So again, this is an area where I would suggest reading the chapter in the textbook. I'd suggest to have a good functional working knowledge of this, have a functional knowledge of the half dozen or so cases that Steve talks about, the main ones, and where the various components are in the Copyright Act to be able to do that, because it's 4 marks, 2 marks, you're going to have sources. So fundamentally, you have to know about, well, what is copyright? What things are protected by copyright? Does copyright protect ideas? No! Copyright protects works. You have to, what's in your head is not relevant. All right? Even if what's in your head and you're talking to other people, if it's not written down or recorded or something's created in some way, there's no protection doing that. You'll need to go and explain that. And I'm not going to tell you, but you guys can go off and trot away and find your own little bit of research for an appropriate place in the Copyright Act to actually essentially source that particular point. And there might be a case there somewhere as well, involving a jockey, maybe. You want to talk about that. All right. You need to also then talk about copyright in terms of ownership. What does it mean to own copyright? When works come into existence, who owns it? And so you'll have to do that in relation to employee-employer, contractual relationships, in terms of moral rights. Describe and define moral rights as well. And again, it's really for you guys, because each of these things, look, every person in this room is capable of getting, at least a half mark on each of these. They're only out of 2. You can just do it with your knowledge right now. In fact, to be honest, you can say pretty much anything. You get the first half mark. Getting the full 2 marks requires both thought and careful, correct citation in terms of doing that. So that's what you find in. Look, I've taught tax for a few years as well, where you'll get things that are worth not very many marks, and it's actually pretty hard to get 100%. It seems really strange, but it's only worth 2 marks. You just answer this, this, and this. Get 2 out of 2. Well, yeah, but it does require a level of just hitting that nail flush on the head to be able to do that. So you do want to talk about how ownership works after works come into existence. All right. Once somebody's got a copyright and somebody else is breaching it, what can you do? This one's a little bit expansive because there's a whole huge number of things that you can do. Again, you want to be taking the part from the book and have a functional understanding of the Copyright Act to be able to explain what powers that Act gives you, what powers it gives the we don't really care about what the federal police and the customs guys get, because that falls outside the scope of the subject. It's really about what we can do, because copyright's one of those interesting ones where there's powers that are given to government agencies to do things, but there's also powers given to citizens to do things as well, and that they can go to court, ask a judge to do certain things, to have certain orders, and even to do things which normally you can't do at common law. An order, for example, to go and wander into their premises and seize infringing material. So that's actually, you do need to know that, what can actually happen. All right. Okay, you need to know about the works and non-works distinction, particularly in relation to derived works and where there are where you've got a bigger work, or non-work I should say, like a film, and if the film has lots of components in it, how that works with copyright. So if you've got a big film and it's got music in it, how does that operate in relation to it? Because, and again, I used to give the example, I think I probably mentioned it in class, the Triple J. I probably mentioned this in class, I usually do. Triple J had the compilations every year. We didn't have Triple J in New Zealand, but we had the CD at every Christmas, have the CD, and it was the top 30s Triple J songs. The Triple J guys don't own the songs. Right? The copyright, they are granted a license to use them, to put on the album. They have to pay some money to do that, to Sony and to EMI and whoever it is. They don't own the underlying copyright there. What they do own, though, is the compilation. Putting those songs in a particular order and writing Triple J on the front, they have that copyright. That is theirs. They own that. And so you do have to work out, how does that work where there are where you've got a film and a film's got music in it? How does that work in terms of copyright? Or the script for the film, how does that work? What about if the film goes past somebody's artwork? It pans past somebody's copyrighted, or maybe copyright, I'm trying to think of, that was perhaps not a good example. Oh, no, it looks fine. No, it looks fine. How does that work in relation to those things? Because these non-work things like films can have lots of things inside them, derivative works that are inside. You guys have to work out how to explain how that's going to fit in a scenario. It's not a very long scenario, it's like 4 sentences, but you'll have to explain that. And the succinctness of your answer is how you're going to get the best results there. And you'll need to know about injunctions. So that's it. I'm going to leave it at that. That's for you guys to go and do, because the question's only like 10 words long. Right. Yeah, it's only 10 past 7. Okay. The final question for this is the miscellaneous one. Basically, it's questions from across the entire subject. So I have to be a little bit careful about how to do this, just directing you guys to do this. But there are going to be parts of the subject that are quite large that nonetheless I haven't put elsewhere in there. So examples are patents, misrepresentation and misleading conduct, and misleading and deceptive conduct. So both common law misrepresentation and misleading and deceptive conduct under the Australian consumer law. Those things are they're actually relatively large parts of this subject that aren't otherwise included in the exam. So they will have only small questions at the end. And again, if you are given a 1-mark question, you can give it a 1-mark response, which is usually just a sentence response. If it's a 2-mark question, you've got to have sources. You've got to have you've got to back up what you're saying with authority from somewhere. Okay, yeah, so basically it is all of the other areas which were quite large when we were doing the first part of the subject, but relatively minor now in terms of marks. Bailment. You have to know how bailment works. The difference between voluntary and involuntary bailment. Voluntary, involuntary, and bailment for reward. So if you're getting paid to do something, even if it's not strictly speaking under a contract for whatever reason, that is different from being a voluntary bailee, and what's the last one? An involuntary bailee as well. When you've accidentally ended up with somebody's stuff in terms of the duties, you need to be able to explain the duties of what the bailee have. You're also going to have to explain the duties of what a bailor have. What is the main duty that a bailor usually has in relation to this? Usually, the bailor is giving a person something to do something with some goods. Usually, you've got to pay them unless it's gratuitous. You usually got to pay them. You've also got to give the goods to them. and let them do their job. If you're giving, bailment's a really curious area of law. It's very old. It predates contract and tort. If you're trying to get your head around that, it's old. It goes back to ye old times. The idea of looking after stuff goes back to the time when if your stuff dies, you die. In terms of particular things like animals and crops and equipment and stuff, arms. So you talk about the duties of bailee and the different categories and duties of the bailor. It's fine. And you need to talk about agency, the agent-principal relationship, in particular, the principle of vicarious liability. You need to know what vicarious liability is. You need to know what strict liability is. Strict liability, by the way, in civil law is usually used in situations to describe where you can become liable without any mental element. It's really the one of the better definitions of that. What's the classic example of a place where you can become liable in this subject that we learned about? What's one area, one part of law where there is no mental element, no thought goes into it, you're just held liable? Because contract has an intent element. You have the intention to have legal relations. It's an element of contracts. It's not that. It's tort, yep. More specifically, it's negligence. Negligence is a tort of strict liability. There is no mental element. If you owe someone a duty of care and you fall below that standard, it doesn't matter what you were thinking at the time. Who cares? Not relevant. You've fallen below the standard, therefore, and also it doesn't matter if it's not your fault. Somebody else comes in and somehow causes you to fall below the standard. Too bad. Too bad. How's that? Okay, so you need to know about that. You need to know vicarious liability and strict liability. Liens. I talked about liens. I will not ask a question on the common law innkeeper's lien because that's very, very narrow. I don't even know why I leave it in the subject. I find it very funny. But you do need to know the other sorts of liens. Do you guys remember what a lien was? It's an unusual spelling. It's like Lein. It's pronounced lean. And it's that idea, like when you go to car mechanics and you don't pay your bill, what can they do? Hold on to your car. Can they sell it? Nah. But they can hold on to it till you pay. I remember a guy came in when I was working at the petrol station. I was a young fella, my teens, early 20s. And he came in and he had, this is going to sound really, really lame in, 2019. But in 1997, this was awesome. Guy came in and he had a device that lets you play CDs through the tape player, because you had tape players on stereos at the time. And so it was a CD player. You could put a CD in it because we had CDs, but you could put it in the tape deck, which was really cool. So I had a tape deck player in my car. And the guy came in, it was $20 petrol, and he didn't come back for like 6 weeks. And I just said to the boss, can I pay the $20? And he's like, yeah. Done. So then I had that. Never saw that guy again. Strictly speaking, could I do that? Probably not. At least up until the point where it becomes abandoned. All right. And again, it's a test of reasonableness here. At what point in time is it abandoned? 6 weeks? Yeah, I was probably pushing it a little bit. But I actually did have another situation. Ironically, it actually almost the exact same time, where one of the customers who used to come into the same petrol station had a boat business. He repaired boats and did boats and sold boats. And my father actually had his father's boat. It wasn't a very good boat. It was a pretty rubbish boat. But anyway, took it to there to be repaired. And then Dad never really got back to the guy. So he would come in and talk to me and say, oh, you got to come pick this boat up. You want to do the work on it. It's been there for like 2 months. And I just forget to tell my father. I just forgot. And I forgot for months and months and months. And eventually, after a long period of time, this guy is just like, if you don't want this boat, tell your dad, come and get it. Otherwise, I'll get rid of it. And I still forgot to mention the boat. I'm useless. And then, so this guy, then the boat place he went and took the boat, I think duck hunting one year. Duck hunting, it's a sport, people do it apparently, and it sank. And we weren't too sure. It wasn't a very expensive boat, but we weren't really too sure how and where the liability sat for that. Because, I mean, it kind of sounds like it was my fault, I suppose. But was it? I don't know. I never quite worked that out. I never really thought about it until now because it's a little bit embarrassing. But nonetheless, there is a point in time where things will become abandoned. But it's a question of degree. And for you guys in business, never assume stuff is abandoned. That's up. In residential tenancy, it happens all the time. People leave things, they go away, they look like they've abandoned because they stop paying rent. And if you stop paying rent, you would think that your stuff is going to become forfeit. No. Tenants have a remarkable amount of power. And so they do come back all the time and say, where's my stuff? And they're like, you left here 18 months ago. And they're like, it doesn't matter. You had to, the landlord is supposed to take the stuff and store it at their expense for a long time. I think it might be 12 months. And take reasonable steps to contact the person who's abandoned. And I had one quite awful case, really. And it's one of those really good examples where you hear one side of a story, all right, and you feel sympathetic to somebody, and then you hear the other side. And so I did work for the homelessness clinic when they had a law right, it's called. Used to have an office in Townsville. The funding ran out. Sad story. Sob. And one of our clients had come and to say her old flatmates threw out all her stuff, threw out all her clothes, threw everything, even though she'd gone away. Because she'd gone away, disappeared, didn't pay rent for 6 weeks. All right, and then came back. 6 weeks, might have been longer. Maybe about 2 months. Came back, where's my stuff? We've thrown it away. And so she wanted us to prepare, legal stuff to try and make some sort of claim for compensation for her stuff and her clothes. And that sounds pretty reasonable, doesn't it? So it turns out what had happened turns out hadn't paid rent for quite a long time before she abandoned, but that was fine. When she had abandoned, after about a month, they went into her room, did find all their stuff, and there were syringes everywhere, like used syringes. And so they contacted the police and said, what do we do? And they said, carefully dispose of all of the syringes and all of the stuff. And they did. They followed the lawful police directions to go and dispose of all the stuff. So it's funny how that works, where you get two stories. They threw away all my clothes. It's like, actually, we threw away all your drug paraphernalia. Because it was a health and safety hazard. So anyway, two sides of every story. Hopefully that person never listens to this recording. Good. Okay, what's next? Oh, we're almost done. All right, legal history. It's a bit mean of me to put that in. There's only about 5 or 6 critical points in legal history in Australia, and I'll tell you what they are. You can argue that 1788. What's 1788? Non-Australians want to tell me what happened in 1788? We'll turn this into a quiz. This is great. We're going to turn this into a quiz. Well, I'll start even earlier than that. What happened in 1215? All right, quiz time. Quiz time, MBA students. You're all master's level students. What happened in the year 1215? Magna Carta. 1 point over there. Very good job. Magna Carta is the point in time where the absolute power of the monarch became limited to some extent in that he needed to call Parliament to do some things. All right? First one. 1689. What happened in 1689? Legal history. What happened in 1688, the king got shirt-fronted, like Tony Abbott wanted to do to Vladimir Putin. Good luck with that. They basically found a pair of Dutch nobles, William and Mary, and said, hey, you want to come and be King, Queen of England? And they went, yep. And they said, okay, we've got some rules. And those rules were enshrined in a document, and that document is called the Bill of Rights. And they limit the absolute power of the king or queen, monarch, in terms of raising revenue and having armies and so on. And again, gave more power to Parliament to do things, limits the absolute power of the monarch. At that point, the monarch starts to become more of a figurehead, and Parliament starts to become more preeminent. That's the Bill of Rights. All right, well, then it was the next year, 1788. Have we worked this one out yet? First Fleet. Good job. Good job. Maybe not a good job if you're an Indigenous Australian, but the British fleet arrived in Botany Bay, I think. Did I get that right, Australians? Is that where it was? Which turns out to actually be pretty rubbish. It was a pretty bad choice. And it turns out Sydney Harbour was actually much better. It was just the next one up. And that is where essentially what we call the reception of British common law occurs on the eastern part of the continent. There's actually a few other years they use for the other parts, but that's not outside the scope of the subject. All right, reception of British law, and for a long time there was no existing law because the land was what? Terra nullius, land belonging to no one. There were no civilized people that lived there. Therefore, all of this is now the domain of who would it have been? King George the Third, maybe? George the Third, something like that. Okay, next year is 1901. What happened? Yeah, the Federation of Australia occurs there. So the colonies of Australia became states in 1901, and the federal government came into existence. Now, a few other things. To be honest, not much actually happened in 1901. It was a big New Year's party like any other. The High Court didn't get formed for a few more years. They didn't do very much. And appreciate the High Court for a long time wasn't the highest court in Australia. You could just appeal to the Privy Council. Right? And I don't know if I put them in this subject, but they started to abolish appeals. First from the federal courts in the late 60s, then from the state Supreme Courts, I think directly, maybe you're appealing from the High Court to the Privy Council. And then the final year that you need to know is 1986. Complete cut ties with the United Kingdom, which is kind of funny because the head of the executive, or the figurehead, is still Elizabeth Windsor. It's the same physical person, but it's two distinct roles. And again, for those, if you hang around Australia long enough and you get your visas all sorted, it takes ages and stack tons of money. But if you do that, it's always worthwhile. And you do a little citizenship ceremony, and there'll be a picture, a little cut-out picture of the Queen of Australia. And that's what she's referred to in relation here. But basically, the UK, they passed legislation that says we will no longer make any laws about Australia, and their laws will not affect us, and vice versa. Australia Act. And that is the end of that. There was one other date, though, which I think is important, which was 1992. What happened in 1992? It's the Mabo decision. What that said is that, look, you know how there was no one living here? Well, it turns out there were people living here. And because of the very nature of the British common law, that people living in a place and having habitual ties to it means that when British law is received into that land, that customary law actually forms part of the common law. All right, and this had been misapplied for the previous 204 years. Sorry about that, Indigenous Australians. Here's some guidelines from the High Court as to how you can make a claim that you and your people in a particular area had predated the reception of British law. Therefore, your claim to that land is something that must be incorporated into the common law itself and therefore recognised. Some people say that overthrows the doctrine of terra nullius. That's completely false. Have you ever heard that phrase? You can tell people, say, no. The doctrine still applies. It's just that the High Court recognised there were people already in Australia in places. Not everywhere, There are no people in Macquarie Island. Terra Nullius still applies to Macquarie Island. It still applies to the Simpson Desert. It still applies to places where people never were. It just doesn't apply to places where people were. It's not really overthrown the doctrine. It's just demonstrated that it had been misapplied to the Australian mainland and Tasmania. Anyway. All right, so I asked a question, but actually, do you guys want to hear something really annoying? I actually only asked a question about one of those things. There you go. One of those things you're going to have to talk about. Good luck. Good luck. I think you're going to be fine. I think you're going to be fine. And that's it. That's it. It's 7:30 now. So, look, it's really for you guys from this point forward. You've got 1 week. That's the downside to getting the extension on the PBL tasks. You got a week to prep for the exam. It's not particularly challenging, but you do want from this point forward to spend some time, a serious amount of time going through it, particularly copyright. I'd go through that. Make sure you're able to apply those fixes and chatters rules, because those are easy marks. Those are easy marks. Copyright's the one where you're going to have to go through and do that. Did I mention there's a question about patents? Did I mention patents? I did. Okay, good. You have to know functionally how patents work as well. That is it. That's a little scary, isn't it? Yeah. Do you guys? Basically, I haven't got much time over the next week, but I'm happy to go if you guys want to have a session. Is there any? Is during the day good for you guys, or in the evenings, on the weekends? I'm here all weekend, and I'm happy to just make some time if you guys want to come either collectively or a small group or what have you. Does any of this sound useful over the weekend? Because I'll literally book in a time. Saturday, Sunday, both. I'll come down for Saturday. How about I just do both? We'll just come down for 45 minutes, and we'll just try and thrash things out. So, do you want to pick a particular time? Like, is midday? I don't know. It's really up to you guys. So 11? Do you want 11 o'clock? 11 o'clock on Sunday. All right. I'll send an email out. We'll just go and be here. But literally, I'm here. And if you guys do want to organise a group, I'll be here. I'll be in level 1 or just what have you. Just knock on the door and just barge in and ask me questions. Because it's really for you guys from this point forward, prepping model answers for stuff. Explaining legal rules, having citations for those. Is because it's different. It's just different from a closed book exam. You are not limited. The stuff that I've told you tonight is pretty much the exam in terms of what you need to know, in terms of what's in your head. The rest of it is being able to express it well. That's really the rest of it. Okay, and that, Emma, if you're there, over there. No, I mean, yeah, no. No checks, no bank fee, no debt, no negotiable instruments, no liquidations, no trusts, no tort other than the tort of negligence. So there's no trespass, conversion, defamation. As it happens, no, I didn't put sale of good stuff in the subject. Well, there is a question on that, which is the it's to do with misleading deceptive conduct. Oh no, there's none of the consumer guarantees. No, you don't have to worry about sections 54 to 65. I didn't put that in this year. Good job. Good question. All right, team, I'm going to close this off for the last time. Now, just make note that I'll leave this up, obviously, for the next week, for you guys to go back over this, but I'll take it down the day afterwards. It's a little, yeah. And the other thing to note with your exam, it's on the day. I'll be there, so I'll be running the exam. Steve has always done that. Please feel free to not break your ankle or anything walking out. Not like this happened at all. And I'll try as much as possible to keep them around, because it's the library and it's downstairs and it's at night. I'm worried that people might just open the door and go, oh, and so I have to shoo them out. I'll put a sign on the front, but just be a bit mindful of that it may not be quite as whatever. So we're going to aim for 10 past to kick off. If there's any little bits, things I don't want you guys to miss the bus, that's all. And yeah, it's like you'll have to hand your exam scripts in with the stuff. You keep your scrap paper, but that should be fine. Okay, Thanks, team. You guys have been awesome. And we'll aim for Sunday. What did we say? Sunday at 11, did you say? Yeah. Sunday at 11. Okay, sounds good, team. We'll go with that. I'll send that out now.